good day, everybody. This is John Giardinelli of Tyler Law, and today is John's Rants. And we're going to do a little bit different today. I want to cover a bunch of quick topics just to kind of bring you all up to date on a couple of issues that are really hot off the press. First of all, I want to talk about what the DRE is doing, just so you have a good idea. Not too long ago, I'm recording this on March 26th, just so you have a frame of reference. I don't know when they put these out or when you hear them and all that, but this is March 26, 2026, approximately 3 o'clock in the afternoon, my time, 1 o'clock yours. So about a week or so ago, the Department of Real Estate put out a bulletin on the legal implications of using artificial intelligence in your business. They talked about using artificial intelligence in place of a licensed assistant. They talked about advertising. So you need to understand that while there's absolutely nothing wrong with artificial intelligence, I had a meeting this morning with one of the partners of the law firm, and we're using it. But right now, it's not to the level where you can rely on it completely. You've got to verify what you're putting out there. The other issue that is going to come up, and we're going to be putting together a program on this in the very near future. I'll talk to Lori about when, probably within the next couple of weeks. I'll be writing an article and we'll be doing some work on artificial intelligence as it applies to the Code of Ethics. You know, obviously your license is critical, nobody's going to argue that, but issues relating to your ethical responsibility, for example, Article 12 dealing with advertising and the use of artificial intelligence, artificial intelligence as it relates to the multiple listing service, and all of that is going to be critically important. The other issue, of course, is how do you train if you're a broker? What kind of policies do you do? I've got a policy that I'll be forwarding to Lori in the next week or so that we've drafted, and it's a brokerage policy that you'll be able to have and use, that I think has got some pretty good points in it, so long as you follow it. But the other thing that the Department of Real Estate is doing is they're working on some rules relating to escrow distribution. And so here's the issue. And we've been having this conversation now for a couple of months, but they're getting close to giving us what I think we're going to want to hear relative to getting paid. So here's the scenario: is technically the commissions belong to the broker. The residential purchase agreement at paragraph 19 provides that the parties are contracting, among other things, that the payment of commission makes the real estate brokerages involved in the transaction third-party beneficiaries to the proceeds, and that actually means that they're entitled as a party to get paid whatever the agreement is. That's why escrow is often asked to see the listing agreement and the buyer representation agreement to confirm what the numbers are. The problem is, and the law does authorize that that a commission compensation, can be paid out of proceeds by escrow to the brokerage. Well, there's a couple of issues. Number one is there's different kinds of escrows, right? There's the broker-owned escrow, which is controlled by the Department of Real Estate. There's the escrow that is public in nature and controlled by the Department of Finance. And then, of course, on a smaller scale but still relevant, is the trust company escrows controlled by the Department of Insurance, where you've got different regulations. What we're trying to do is get those regulations where they're all the same. Then the question is, once we get them to where they're integrated with each other, so nobody has to guess what kind of escrow I'm dealing with and all that, who gets the money? Well, clearly the broker or brokerage gets their money, but then the question comes up, well, can the broker assign the money that is actually going to be paid through the brokerage to the agent, directly to the agent, so they can be paid quicker and more efficiently? The answer is probably going to be yes. I don't have a crystal ball, but I've been in contact with the people drafting this resolution, and I'm suspecting that the agent who handled the transaction or their wholly owned corporation, with some work still being done on defining what that actually means, will be entitled to be paid. So conceivably, the escrow company would write 4 checks, one to each brokerage. So if there's 2 brokers involved, one to each brokerage, that's 2, and then one to each agent, it's another 2, or their wholly owned corporation. Some of the issues that still need to be worked out are team payments and transaction coordinators. But what's pretty clear to me is I think there's going to be a real clear gap or clear boundary on paying things like escrow companies are being asked to pay tuitions and bills, and I don't think that's going to be allowed any longer. So we'll know a better answer probably in the next a month or 2 from today's date. We're also monitoring the new code, the regulation that went into effect on January the 1st. It says that the amount of time that a buyer broker agreement can last is no more than 90 days. And of course, CAR put a default provision in their BRBC to hopefully save people that make that mistake of making it longer than 90 days, to say anything longer than 90 days defaults back to 90 days, hoping to save some of these people that make that mistake. So there's that. But there's still an issue that needs to be clarified, and that's that state law and the MLS rules are different in one aspect. State law says that you're to have a buyer representation agreement before you start touring, but in no event later than when you write up an offer. And if you don't have that, you don't get paid. But the MLS rules don't make that adjustment. They say you will have a written agreement before you start touring an MLS listed property. And therefore, if you don't have a written agreement, even though you're technically assuming that you made an effort to get a written agreement, but you don't have one, that you're okay under state law, so long as you can prove that you tried and couldn't get a buyer-broker agreement, but you're still in violation of the MLS rules, which pretty clearly state that you're going to pay a $2,500 fine. So one of the issues that keeps coming up is your buyer wants to look at a property. Maybe it's your listing and they want to get in your car and drive over and look at it. You have to have a BRBC if that property is in the MLS, or if you want to look at it 3 or 4 properties. And again, the best solution for that is obviously the BRBC for somebody that's never met you before is a pretty complicated document. It's 5 pages, but there's a lot of attachments, bundles. There's the wire fraud advisory. There's all the other documents that go with it. I think it's a total of 18 pages, roughly ballpark. Use the PVRA form, which is a short version of a buyer representation agreement. It complies with the statute, complies with MLS rules, and complies with the NAR $1 billion settlement. It's a good thing. It's only good for 30 days, and it only allows, I think, 3 or 4 properties. And so, if they're not willing to sign the BRBC for more than 30 days, but you want to show them a couple of properties, comply with MLS rules, and comply with state law, and get paid, frankly, if you do write up a successful offer, then that's your key. It also would work if a buyer comes into an open house and wants to work with you who are sitting in open house to go look at some other properties. So take a look at that form. It's a great little form, and again, does solve that short-term problem if you need to do that. Some other regulations that we're looking for in the next couple of months is the Department of Real Estate is going to add a section to the broker supervision rules regarding mandatory education, and the Department of Real Estate is looking to create some regulations for the new AB 723, which is the photo app rules. The photo disclosure rules. That's the rule where if you alter a digital image for advertising purposes, either directly or through an advertising entity, you must disclose if it is an altered photograph or image, such as staging and virtual staging and all that. And so they're probably going to write up some regulations on that fairly soon. CAR is going to be coming out with some forms. We're going to be doing a newsletter as soon as we know what those forms are. It's only March. Their forms will be coming out in June. They made some changes to the forms back in December. They added some language regarding in the BRBC and some other forms. They cleaned up some other forms, and so read our newsletter. It's available to all the members, and it's available at the association's website. One of the other issues that's come up a lot is the so-called FinCEN disclosure. Now, that disclosure requires a fairly complicated set of rules regarding disclosing cash over a certain amount. Applies to a lot of properties, applies to almost every transaction, and it's a little bit complicated because it's very how do I say this? Poorly written, I guess, would be the nicest way to say it. And as of today's date, again, March 26th, a court in Texas has stayed the enforcement, but it'll come back. Whether it'll come back immediately on appeal or because they clean up what the court was concerned about, it'll be back. And so we'll keep you posted in whatever form Lori and I discuss and talk about, and you'll know what needs to be known. Right now, the disclosure can be handled in the RPA. Whether or not you're going to do it, since the court has stayed the enforcement or not, whether CAR is going to change its forms at this moment, I don't know. But understand this, that FinCEN appears to only apply to escrow companies or maybe even title companies, but that's not true. There's a much broader application. So one of the things you can do for yourself, maybe not today because again it's not something that's required immediately, but the CAR has a quick guide on the FinCEN disclosure. It's really quite good, and they'll update it according to the conversations I've had with the CAR lawyers when the court makes a decision on any changes that need to be made. So that's coming down the road. The next time I do a rant, I'm going to cover private listings. Those of you that read Inman or any of the other online newspapers know that the issues between the multiple listing services, the private listing services, is at an all-time peak high. The volume has been pulled up. There's a lot of arguments on either side, but as a defense lawyer, I look at it as what is your legal obligation to your client. Certainly can use a private listing under certain circumstances. Certainly you have the ability to work with the Zillow requirements. That's not an issue. The issue is the client making a clear and knowing decision on where they want their property listed. They want their property listed in CRMLS, which is a much broader audience. That's fine. If they want to go a little narrower, that's fine. I'm not getting into that discussion today. I probably will down the road. But the issue is it the client's decision, or did you persuade them to do that? Because if it's for your benefit, but isn't clear that it's for your client's benefit, that's where I think the issue is going to resolve itself. For those of you that do property management, be aware that there's a situation going on right now where there are what we call testers that go around, and they could be government testers or they could be private attorney testers. And what they're doing is they're trying to get you to discriminate by answering a question the wrong way regarding the availability of your rental stock for Section 8 housing. And if you answer the question incorrectly, then you could get yourself in some trouble. So make sure that you stay away from answering those questions. If somebody says, is the property available for Section 8 housing? There's a correct answer, yes or no. If it's no, it better not be because of discriminatory reasons. It better be something that is appropriate under the law and the regulations. What I would do, because time doesn't allow me to do this today because these are such short sessions, but download the CAR guide on Section 8 housing and make sure you answer those questions correctly so that you don't run afoul of the rules. Well, that's basically it for today. A lot of stuff going on. We're going to be doing a article on the Code of Ethics and artificial intelligence. We're going to be working more closely on these private listings, and we're going to be providing the membership with a artificial intelligence manual to insert into your office policy manuals so that you can train and guide your agents on the appropriate use of artificial intelligence. So for now, I think I'm going to cut it off, but I hope all of you have a great and glorious week ahead as you continue to serve the public needs. Thank you very much.